no court may review it. That's a position that no court has ever embraced, and until this year, power no president has even asserted. We do not ask this court to review the president's emergency declaration itself, but the judiciary is duty-bound to review IEEPA's other statutory requirements, whether the emergency declared creates an unusual and extraordinary threat, and whether the tariffs deal.
Mr. Marshall, in IEEPA, you acknowledge the terms prevent or prohibit importation, correct?
Yes.
The president has the power to do that?
Yes.
So what would the term regulate importation mean if not applying tariffs?
The quantity, the quality, the type, the nature of those imports. And so if there was a particular product that was being imported that in the quality.
You're talking about a quota, but wouldn't that be preventing the importation?
I should not have said quantity. I mean the quality of imports or the character of those imports. So I think that the type of them, whether they're large or small, the nature of them would all be under that provision. Which ports of entry they can be imported to. There could be a number of things that could be regulations of imports that are not of
could
that.
Could the president apply a prohibitive tariff?
No, Your Honor. Under our interpretation and our understanding of what regulate means, he could not, because but he could bar importation entirely. Could embargo a particular country, could embargo a particular type of product.
200% tariff.
We don't think he can do that because he has the authority to bar importation entirely, but not to impose a tariff. And I mean, I think it may be useful to the court to understand why our view is that it's not controlled by Yoshida's approach to that question. And I think that there are statutory differences and there are jurisprudential differences between Yoshida and now. The statutory differences are section 122, which says that the one use that this has ever had is now off the table under footnote 33 of Yoshida. And the jurisprudential difference is the major questions doctrine, which is now.
Can I add that 122? It addresses balance of payments. I don't actually understand there to be a balance of payments issue. There's a trade deficit issue, which can be a component of balance of payments, but I don't even know if we have a balance of payments problem. I mean, because balance of payments involves things other than trade deficits. So 122, is it only for balance of payments? And do we have a balance of payments issue?
The mechanism that section 122 uses to address balance of payments is the balance of trade. And so to the extent that Congress decided that the one time it was going to authorize tariffs in order to rebalance trade was when there was a balance of payments issue, we think that that's the decision that was taken in section 122, was to say, if you're going to use tariffs to try to change the balance of trade, the only reason that's available to do that is a balance of payments issue.
So may I ask, last week I asked one of the parties whether IEEPA could be used to address a massive anti-dumping problem where Congress obviously has created an anti-dumping statute. It takes about a year, however, for the Department of Commerce, the U.S. International Trade Commission to apply anti-dumping duties. If the president were to find there was such an emergency and wanted to act immediately, wouldn't IEEPA be the appropriate statute then to act where other authority that Congress had provided under their constitutional powers was not sufficient?
We don't think so, Your Honor. And the reason is because we think that the unusual and extraordinary threat, extraordinary in our understanding, and we've described this in more detail in the reply brief, is the type of emergency that Congress didn't anticipate. Because it's so that extraordinary goes to the character of the emergency, unusual goes to whether it's been a historical fact. So the fact that Congress has decided it may take a year to do it. That's Congress's decision. It's the Congress's delegated authority. We're in the third category of maple leaf about whether there's a delegation of authority at all. And it's Congress's authority to decide what to transmit to the executive and what not to transmit. And if there need to be expedited procedures under Section 301, that's for Congress to decide, not for the president to usurp.
So this case also involves tariffs that have been imposed to deal with as characterized, the fentanyl crisis. Why is that impermissible? Those kinds of tariffs, which are basically leverage to deal with the crisis. How is it different from President Carter's freeze on Iranian assets in the U.S. to deal with the hostage crisis?
I think that the setting aside the question of tariffs at all, because I think you're asking about whether the deal with provision works with how deals with operates. And I think that if this court takes the approach that we saw from the Northern District of Florida and takes the approach that IEEPA is effectively a reenactment of Yoshida, then it takes all of Yoshida. And Yoshida says there needs to be a reasonable relationship between the threat confronted and the action imposed. And it says the courts will not hesitate to take that action. And when it's being used purely as leverage, there's not a mechanical action that addresses the particular issue. Now, the government cites in its response brief a 2021 IEEPA executive order that is also aimed at narcotics trafficking. But that was an asset freeze meant directly to address the capabilities of people who were taking drug trafficking or who were engaged in drug trafficking. And I think that the Iranian situation is much the same, that it's disabling the capacity of Iran to be a threat using those asset freeze authorities, as opposed to just saying, we're going to do an across the board with some exceptions, 25% or 10% tariff on a particular country, or in the context of China, a 20% tariff on that. And I think part of the way that the court can look at that is to look that on February 1, we have the tariffs imposed, the fentanyl tariffs imposed. On February 3rd or 4th, we have them paused. And so we know that it's not the mechanical operation of the tariffs, it's only for leverage. And I think that the reason that the court needs to engage in that inquiry is that if it is only for leverage, it undoes the entirety of the deal with provision of IEEPA, that Congress was relying on the Federal Circuit's predecessors' commitment to hold the executive to a reasonable relationship test between the emergency confronted and the action imposed. And leverage undoes that entirely. If there's leverage as an option, then all you really need is a nexus to the country itself. There doesn't need to be anything else.
So do you have a home run case, a judicial decision, which supports the principle that you are trying to establish here?
So Yoshida. I think that's the home run case, is that it says that the courts will not hesitate to require a reasonable relationship. And that is a case where mechanically the laws of supply and demand cause there to be a reduction in imports to the United States, which mechanically addressed the balance of payments problem. And that's the type of tight relationship that Congress was relying on at the time that it enacted IEEPA.
Okay. Balance of payments. Okay. You have drugs and immigration, and your argument is tariffs do not relate to those. Yoshida says those are out. Then you say that balance of payments tariffs are out because they're dealt with by 122. But we don't actually have a declared balance of payments deficit or imbalance, but it only says balance of payments problem. That's what it says in the statute. I don't know what balance of payments problem is. You seem to say a trade deficit is a balance of payments problem.
I hope I'm not miscommunicating about that. I'm making 2 points. One is that balance of trade influences the balance of payments. And secondly, that 122, if you read on beyond just what the problem statement is, and I don't have it in front of me, I'll have to bring this up on rebuttal, that later on it refers specifically to balance of trade as being the mechanism that is used to address it. And so that's the piece of 122. I mean, that's not our only argument with respect to the worldwide tariffs. We also make an argument about unusual, that if you just look at the dictionary definition, it means atypical as a matter of fact, that is the same as what Congress was talking about in its legislative history, that emergencies would be rare and brief. And that's the methodology that's used in cases like Grants Pass to see, is this a usual punishment? And that's the kind of quintessential judicial inquiry that we're asking the court to make. There's no factual dispute about that. The executive order says that it's persistent. It's existed for 50 years. It's been at roughly this depth for 25 years. It's been deeper 2 decades ago. All of that means that this is not an unusual problem. And that links back to Yoshida's discussion of why we have emergency powers at all, that they're used to deal with emergent problems Congress cannot act with the haste necessary to protect the national interest.
So what case can you cite, post IEEPA? Because Yoshida involved an interpretation of TWIA. And you say Yoshida is your home run case. Is there a judicial precedent that you would cite post IEEPA that incorporates Yoshida?
Yesterday's decision of the Northern District of Florida. I don't think so. I mean, I think if the question, there are judicial precedents that I think bear on this question. I think Maple Leaf bears on this question because it says that the court addresses delegations of power. I also think that Zivotofsky addresses the broader question of whether the court needs to address statutory standards that abut to political questions. Your opponents seem to agree that Maple Leaf is, at least in this circuit, our rule on review of presidential action, right? Mm-hmm. But we also have Florsheim. And somehow or another, there has to be a meshing of those 2 cases. We can't review factual findings by the president. But you say he made factual findings and we don't have to disagree with those. But then the president says those factual findings add up to this emergency. Is that another factual finding? That it adds up to an emergency? I guess unusual, extraordinary, unexpected emergency. No, we don't think that something can be so usual that it makes it unusual. We think that unusual means unusual. If the question is, But then we're saying the president cannot make that ultimate factual determination based on these factual determinations. Well, if the question behind the question is about the national security implications of a trade deficit, we think that the executive order really focuses on the trade deficit as the mechanism. And if it were to focus on manufacturing base and the capacity of the United States to rearm quickly, that it would be a different set of tariffs that protected heavy industry, that was focused on military, things that had cross civilian military purposes, as opposed to just saying we're going to have an across the board on all products, with a handful of exceptions type of.
I don't know if I got an answer to my question. My question is the ultimate statement that this is an extraordinary situation and an emergency a factual determination?
No. I think that's a legal determination. So I think that the question of what is the standard for usual and extraordinary is a legal question. What the facts underlying that determination are factual questions. There's not disagreement among the parties about those underlying factual questions. We're just reproducing government data and citing the executive order.
I didn't understand what you wanted me to get out of the Northern District case. It seemed to me that the parties got the judge there involved in merits determination when it wasn't necessary. Because they have these nice books. This is the tariff schedules of the United States. They are a statute. They're the law of the land. This court interprets and deals with those tariffs. I don't understand why this happened in Florida. And, so what do you want me to get out of Florida since I don't know what they were doing?
You don't have to take anything out of Florida. The point I wanted to
mention them.
Well, here's what I wanted to say, and I think this relates to the way that some of the questions were coming out last week, which was that there is an argument that is being made that IEEPA is a reenactment of Yoshida, that it takes Yoshida's standards and imports it into IEEPA. My point is, if that is the case, that it takes all of Yoshida. It takes the parts of Yoshida that say that there has to be a reasonable relationship, that say that there's a limitation, that it doesn't allow the rewriting of the tariff schedules, for example. All of those pieces of Yoshida, footnote 33, it takes along with it as well. And so I'm saying if the Northern District of Florida judge, regardless of whether he needed to get into that inquiry, we don't think he did, but if he was right about that position, which I think the government agrees with, then it has to take all of Yoshida together. It can't say, I accept the piece of Yoshida that says that regulate importation means encompasses tariffs, but I'm going to disregard the back half of Yoshida and all of the limitations that Congress was relying on 2 years later when it enacted IEEPA.
So the case that we're discussing is the case, correct me if I'm wrong, which has been transferred to this court?
That's right. Emily Lay is the case, and it was filed by the government last night in a notice of supplemental authority.
Right. So, and a judge, the district court judge, did state that the Court of International Trade has exclusive jurisdiction.
Which we agree with, which is why we filed here.
Right. Okay.
But he said we had exclusive jurisdiction because IEEPA is a tariff statute.
Well, we disagree with that part.
Okay.
So we disagree with you.
There is another tariff statute, the entire HTSUS, of which these temporary tariffs are a part. That as soon as the president proclaims something, he says which part of the tariff schedules are to be amended, and then the amendments show up. So here we are.
And we agree with that and think it's a straightforward inquiry that doesn't require a conclusion about whether IEEPA covers tariffs or not.
Good, because otherwise there'd be a giant circle going on, depending upon how the decisions came out. So
we also think that giant circles are disfavored in jurisdictional statutes.
Yes.
That you decide whether it arises under the question, and then you decide what court to go to, and then that court decides. And so for that to logically operate, we have to come here, adjudicate the question among reasons because the harmonized tariff schedule of the United States gives this court jurisdiction.
So I agree with my colleagues that giant circles, and with you, counsel, that giant circles are to be disfavored. What I wanted to ask you, though, is to bring you back to unusual and extraordinary. In your discussion of the relationship between the action taken, you're discussing the relationship of the across-the-board type of tariff action here with some of the national security and other domestic manufacturing objectives that are identified in 14257. Where does the court's analysis stop? Where does the president have room to be able to identify the kind of action to take to address an emergency, and the court not be second-guessing that policy call?
With respect to the worldwide tariffs or with respect to the federal tariffs?
Yes. Sorry to not have the question be clear. The question is, you were raising a question as to how these tariffs were related to the objectives stated in the EO, as I understood your point. Where does the court stop in that analysis and not just become basically a second backseat driver to the president in assessing what the emergency is and how it needs to be addressed?
I think it has to see whether there is a reason identified that carries with it reason. I mean, that there has to be a reasonable relationship, that is, that the policy addresses the action. Now, with respect to the fentanyl tariffs, I think the only way in which they are related, and this seems to be by the government's admission, is as a reaction. And our view is that that category of just leverage is not a reasoned relationship of the type that Yoshida endorses.
So,
and unusual and extraordinary is a different threshold question. It doesn't relate to the reasonable relationship question. It relates to whether there is.
Sorry, just very quickly follow up. Isn't leverage getting into a potential motivation for the action as opposed to what the action itself is?
I think that's the only reason relationship that the government is identifying is leverage. And if we say that that's off the table, there's not a factual question. It's just a pure legal question as to whether leverage is a sufficient nexus, whether that is the kind of reasonable relationship that Yoshida was talking about.
Can I go back for a moment to the question of illicit drug crisis? Here, Mexico, Canada, China tariffs are linked to the illicit drug crisis. Do the tariffs actually deal with that threat? Are they? Do they present? Does the illicit drug crisis present an unusual and extraordinary threat?
We don't challenge the unusual and extraordinary. We challenge whether it deals with, which we think deals with, points back to Yoshida's reasonable relationship test. Mm-hmm. So we're not challenging that it's an unusual and extraordinary emergency. What we are challenging is that it doesn't deal with that threat. The types of IEEPA actions that deal with narcotics threats are like the ones that the government cited in its response to the 2021 executive order that was an asset freeze order directed toward the drug trafficking organizations and individuals involved in drug trafficking to stop their capacity to traffic drugs and to use those IEEPA powers, not to say Canada, all Canadian imports or nearly all Canadian imports are going to be subject to a 25% tariff, and hopefully that will change Canada's foreign policy or border policy such that it will favor the United States outcome.
Because your view of IEEPA is that it was designed to actually cabin the power of the president.
Absolutely. Absolutely. I don't need there to be any dispute in the legislative history about that. And it's a direct response to the challenge that Yoshida lays at the feet of Congress in its conclusion, where it says that if Congress wants the judiciary to address the issue of whether what Yoshida calls an unscrupulous and rampant president who would declare an emergency where none exists, that it's up to Congress to act. That footnote 37 of Yoshida is really specific challenge to Congress and says, if you want us to do this, it's up to you. And my view of both the legislative history and what you look at the statutory changes is that it is tightening under what circumstances the president is allowed to access IEEPA powers.
So what is the role of Congress here? The argument could be made that the president has imposed through the executive order tariffs. If Congress has a different view of the situation, it can attempt to overturn the president's actions. What is the role of the Congress, and could you discuss how that relates to charter?
Well, sure. The role of Congress is to delegate Article I powers to the executive as it sees fit. And the role of Congress is the role of the courts is to enforce those limits. Now, there was a fast track procedure that was created, but once Chadha eliminated what was colloquially known as the two-house veto, that fast track procedure doesn't have the same salience that it does. And so the reliance on the idea that that fast track procedure is a reason to disfavor judicial review, when that was severed from the statute, that argument had to be severed as well. I would also say that we cite other fast tracks, like the Congressional Review Act as a fast track. That exists, but that doesn't displace APA review of rulemaking. We think that both coexist, and they both check the executive.
Okay, after IEEPA came before Chadha, right? So
yes.
So now, is there anything special left for Congress? I mean, a veto-proof, passing the acts by a veto-proof, I guess you don't even call it a majority, but I'll use that word, a veto-proof vote. I mean, that's like just ordinary. Is there anything different? I mean, because Congress can pass a law, president can veto it, and then they can come back and override the veto. So is there anything left that's special in IEEPA for the legislature to do?
Nothing meaningful. I mean, there are some transmission requirements and so forth, some communication requirements. There may be some internal procedures that Congress feels itself bound to. But the fundamental power dynamic is that it takes 2/3 of both houses to undo what the president did. And you could make the same argument about other emergency powers, but that's not the way the Supreme Court has handled them. In Alabama Association of Realtors, in Biden against Nebraska, those were emergency power statutes. But Congress didn't, but the court still just applied the ordinary tools of statutory construction and enforced the limits that Congress had created.
I want to bother you again about section 122. I know you said you don't have it before you, but it says in section A, whenever fundamental international payments problems require special import measures to restrict imports, one, to deal with large and serious U.S. balance of payments deficits and other things. But it sounds as if 122 is only for fundamental international payments problems, which I don't know that we have that.
I agree with that, but what it says later is that the mechanism to address that is a balance of trade mechanism for tariffs. And my view is that our view is that when Congress said, if you're going to mess with balance of trade, that this is the mechanism to do that, and the prerequisite for that is a balance of payments problem, that is sort of occupying that field of decision making. And it's also not the only statute I think that we have this argument for. I mean, we also have Section 301 as another instrument to.
No, we have a lot of statutes that deal with a lot of different problems, and the president can put on tariffs under a lot of different statutes. But you were arguing that there was a carve out that from the TWE world, TWEA, from the TWEA world to the IEEPA world, and what has gotten into IEEPA, and that there is this carve out from TWEA, and it's 122.
And on rebuttal, I will try to do a better job of citing the statutory language that I
won't bother you with it
perhaps
anymore.
not remembering. I'll need to draw your attention to the specific piece that I'm trying to refer you to.
I'll stop bothering you.
So could I go into the issue of trade imbalance and the Hines declaration, figure 8. Is U.S. net imports of goods and services as shares of GDP an appropriate measure of a trade imbalance?
Yes.
It is.
And even if you think it's the wrong one, you can just look at the executive order that says a balance is that the balance of goods deficit, balance of trading goods deficit is persistent. And I mean, it's just an antonym of unusual.
Now, the U.S. Customs and Border Protection reported in 2024 that almost 97% of all seized fentanyl was intercepted at the southwest border, while less than 1% was seized at the northern border. The president's executive orders have imposed tariffs equally against both countries. Does that seeming disparity affect our analysis?
I think in the sense that it demonstrates that it's not designed to deal with. I mean, the statutory language is deal with and for no other purpose. And so if the court is just saying, is there a reasoned relationship between the two? That sort of evidence is illustrative of the fact that there isn't a reasoned relationship between the problem confronted and the tariffs imposed.
You also state in your motion that the China tariff orders do not target goods related to drug trafficking and instead apply to almost all goods imported from China. Are tariffs that do not target goods relating to drug trafficking automatically not related to an illegal drug emergency?
It's certainly a factor. I don't want to necessarily limit the possibility that there could be, but I think if you look at the 2021 executive order, though, there was a way to use IEEPA powers that was related in the sense of who were the traffickers and how could they be disabled from continuing to traffic. And part of the way to do that was through asset freezes. So that kind of mechanism, I think, works.
Isn't there room for inducing another country's government to crack down on conditions that impel United States interests?
I don't think
it sounds like you're saying that.
No, I think we're saying that undoes the deal with inquiry. It undoes the inquiry that Yoshida, I think, promised Congress that the courts would impose, which is that there would be a reasoned relationship. Because if it's just leverage, there doesn't need to be a reasoned relationship. It can just be, we want to change the foreign policy of this country. And that's not a limit at all.
And on the question of remedies, is it conceivable that you could win on your APA claim but lose on your ultra vires claim? How might the court reach that outcome?
I guess there are pieces of that claim where you could say that it's statutorily authorized, but the actual tariffs imposed are arbitrary and capricious. I think part of the remedy, the reason for the APA claim is that vacature is an option for the court under the APA, and so that's part of it. I think that if it was a statutory, if we thought there was a statutory limit, then then we would win both. But the remedies are slightly different under an APA claim.
Can I ask you about Maple Leaf? We have a limited review authority. And so which one are we doing here? Are you saying that the president made a clear misconstruction of a governing statute, or that his action was outside delegated authority? Outside of delegated authority, the third category. Okay.
I'd like to go back to 2 points that you made. One relates to this was in your brief and again here on the Congressional Review Act. So that applies to agency action, not action by the president, correct? To what extent does that limit the applicability of the analogy?
Very little. I think that the question is whether the legislature can check the executive. The agencies are all accountable to the president with the exception of potentially independent agencies, but I think the government's position is that those are unconstitutional. And so they're all directly accountable to the president. The president can dictate their action as he has done here.
This is a further argument you're seeking to use to show that the congressional dimension of the IEEPA is not a check on the court's authority to apply the terms of IEEPA to an executive action and action by the president.
That's right. There's two arguments. One is that there are other fast track authorities that don't displace judicial review. And the second is that when Chadha severed the two-house veto, it severed along with it this argument.
So my second question relates to Zivotofsky. You brought the case up, which related to the constitutionality of the statute. So in this case, we're dealing with the application of a statute. Does that limit Zivotofsky's relevance to our consideration here?
We're citing Zivotofsky for the proposition that this is not a political question, because statutory questions are still, even when they abut political questions, that doesn't turn the statutory question into a political question. In Zivotofsky, the statutory question was, what does someone's passport stay, which abutted the question of which governments does the United States recognize? And the second of those questions was a political question, but the first wasn't. And we think it's the same here with emergency declarations, which have historically not been subject to judicial review, is different from the unusual and extraordinary requirement of IEEPA that is layered upon the emergency declaration requirement.
Thank you, counsel. We look forward to hearing from you later.
Thank you, Your Honor.
Thanks. May it please the court. Brett Shoemate on behalf of the defendants. If I could just say at the outset, it's a privilege to be back before the court. I've been a member of the bar of this court for about 10 years. In fact, the last time I was here was before Judge Rustani. So it's a privilege to be back.
It was nice that day.
That's my recollection too.
Good answer.
Your Honors, I don't want to repeat much of what Mr. Hamilton covered with you last week, but I did want to, I think, address a couple points that the court may have had concern about last week, also put this case into context. So if I may, the president acted well within his authority under IEEPA when he imposed tariffs on China, Canada, and Mexico, and the reciprocal tariffs on our trading partners. Each of these actions rest on the president's determination of a national emergency with respect to illegal drugs pouring into our country and trade deficits that have hollowed out our domestic manufacturing base. The purpose of these tariffs is to create pressure. The tariff pressure other countries to change bad behaviors that the president believes are hurting Americans and our national security. And the reciprocal tariffs have the direct effect of reducing our dependence on foreign imports. The tariffs are right now giving the president the leverage he needs.
If you say that the purpose of the tariffs is to create pressure, aren't you playing into Mr. Marshall's argument and the state's briefs that is not of itself an emergency?
No, Your Honor, I'm explaining how this process worked, what the rationale for the decision is. The president identified the emergency, and he has to decide the means to address that emergency, and the means he decided to identify and use are tariffs. And the tariffs are intended to bring our trading partners to the table. And the way that the president has created leverage is to persuade them to change things that they are doing in their countries that are harming Americans, harming our national security.
Okay, it may be a very dandy plan, but it has to meet the statute. Your opponent said that Yoshida said there has to be a direct relationship between the tariffs and the trade imbalance or deficit or whatever you want to call it. It has to solve that problem. That's what he argued. So is he right? Is he wrong?
He is not right. So I will concede that the one thing that this court can review and decide is the interpretive question. Does the statute authorize tariffs? That's where the court's inquiry ends. The other two arguments he's making about whether this is unusual and extraordinary and whether the means fit within the statute, those are political questions.
Now that was also discussed. I know you're familiar with the hearing last week. And looking at Yoshida, right, which says that, a scheme which would permit a disregard or rewriting of the, let's say, the harmonized tariff system was not being sanctioned by Yoshida. And then you look at IEEPA, so the argument goes, which actually imports these standards which cabin the president's authority. Are you saying that there is no role for the court because essentially the questions of whether something is an unusual and extraordinary threat is a political question?
Yes, Your Honor. I think the role for the court to play is to decide the threshold interpretive question, but it is not a role for the court to decide whether the president has appropriately used that authority. And that is because Congress set up a scheme whereby Congress is the one to review whether the president's action is consistent with the law. I think my friend understated Congress's role in this process. There are a number of procedural checks on the president that he has to consult with Congress, submit reports to Congress, and that report has to explain what he did, why he did it, why it complies with the statute. And the
Do we have the report of the consultation with Congress before this was done?
I don't know if it's in the record.
This is APA review. I guess we should have some kind of evidence of what happened.
Well, I think that's a great point, Your Honor, because this is not APA review. And what I've heard from my friend is a lot, what sounds a lot like APA review. The president didn't reasonably explain. There's not a rational connection. Standards that you're very familiar with in the Department of Commerce cases, right? That's not this case. This is a case in which the president has been expressly delegated an extraordinary power by Congress. And Congress has imposed its own checks on that power. And the only check on that power is Congress's ability to disapprove what the president has done. And Congress took a vote in it.
Enacting a normal statute over veto, right? That's Congress's power here.
Yes.
But then you said Congress had other roles to play. And one you said was consult with Congress before this happened. And I just want to know if there was a report of a consultation with Congress before this happened.
I don't know, Your Honor.
Okay.
The statute requires consultation. The statute requires a report to Congress that explains exactly what my friend is complaining is not in the record before the court. All of that.
If there's no report to Congress, is this all void?
No, Your Honor. The court is not in a position where it reviews the president's compliance with IEEPA. The court can only review the question and decide what the statute means.
Okay. I thought one of the things in Maple Leaf was procedural, a procedural violation. The court could decide whether the procedures were followed. I didn't really think this case was about procedures, but you said a procedure. So now I'm asking you, am I supposed to disregard that part of Maple Leaf?
No, I think the operative section of Maple Leaf is the clear misconstruction standard that applies to the court's review of the statute itself. But when it comes to the president's application and compliance with the statute, that is outside judicial review because it raises inherently political questions. And so if the president can
say inherently political questions, but one of the counters is we do have a constitution. We do have a constitution where basically the tariff power is lodged in the Congress. And there is a question of whether under Algonquin, there's an intelligible principle by which that power is in some ways delegated to another branch of government. What is the intelligible principle here?
Your Honor, I think there are many intelligible principles here. Just to start with the statute. So number one, there has to be an emergency finding. As Yoshida said, that's a political check on the president. Number two, the statute identifies what type of emergency is required. It's an unusual and extraordinary emergency. Second, it has to arise from outside the United States. Congress also specified 9 particular means in the statute by which the president can choose. Everything from investigate to regulate to shut down imports altogether. And finally, what I think is really telling is the statute contains exceptions, right? IEEPA says the president can't bar the importation of information like films, books, things like that. That's a really good signal that Congress thought through what are the outer bounds of this statute. But we're in the heartland of the statute. We're in the phrase regulation regulate importation, which, as we've discussed about Yoshida, it's the same phrase.
Well, so going back to Yoshida, is the requirement that the president's actions, quote, may only be exercised to deal with an unusual and extraordinary threat under 1702, 50 U.S.C. 1702, the same as or narrower than Yoshida's concept of an eminently reasonable relationship to the emergency confronted?
I think those are different analyses. I think the plaintiffs are tied to what the plaintiffs are arguing. I think they're raising two separate arguments. One is the president hasn't explained well enough that this is an unusual and extraordinary emergency. And second, even if it is the right type of emergency, the president hasn't rationally explained how the means he chose address the emergency. And I'm saying both of those are political questions. And what they're trying to do, they obviously can't get through the front door because and ask for the court to review the emergency declaration, but they're trying to get in through the back door, APA type review, by challenging subsets of the emergency declaration and what the president concluded. Our position is all of that is off the table because it is Congress's role to review the president's compliance.
So last week, peanut butter was invoked. Let me ask you about, and correct me on the pronunciation, potash? Okay. The plaintiffs argue that adjustment to the tariff rates, such as the potash adjustment, quote, eliminate the arbitrary nature of the tariffs vis-a-vis drug trafficking or the fentanyl crisis. How do you respond to that argument?
So again, it sounds like an arbitrary and capricious APA claim, which you can't bring against the president. But I can imagine scenarios, even going back to the peanut butter hypothetical. Imagine the peanut butter is coming from China and it's laced with fentanyl and it's being imported through Mexico. You can't constrain the president's ability to respond to this emergency or a future emergency based on, certain hypotheticals that the court and others are not privy to all the information the president has before him, some of which may be classified.
So are you saying that, okay, if a peanut butter is laced with fentanyl, then there is a relationship between the product and fentanyl? Does there need to be that kind of nexus for tariffs to be legitimately imposed, ordered by executive orders?
I don't think you need something that clearly tied to the emergency, but I think all the president has to do under the statute is identify an unusual and extraordinary emergency, which he's done, and identify the means that he's going to use to address that emergency. And that's what he's done. And it's not for the rule of a court to second guess whether the president has chosen the right means or adequately explained himself. Because at least to the next question, if you find his explanation inadequate, do you remand to the president? Do you direct him to provide additional explanation? It leads to uncomfortable situations.
Can you explain how the standard you're offering us here, though, is consistent with Biden v. Nebraska? In the state's brief, they argue that basically what the government was arguing last week and argues again this week leads us to essentially a situation of unreviewable authority, tariffs of any level, of any breadth, for any period of time. Why is that not the case?
It's not the case because, again, the court can review the legal question of whether the statute authorizes tariffs. But there's a long history of the president invoking the National Emergencies Act and IEEPA to impose all sorts of remedies that don't get reviewed. That is the presumption. Now, I'm glad you raised the major questions. Sorry.
No, I was going to say if the court were to find that tariffs are a legitimate utilization of the IEEPA authority, at that point it's all hands off. There is no nexus between the emergency declaration and the unusual and extraordinary standard. There's no other form of review. And how is that consistent with Biden v. Nebraska?
Because we're in a unique emergencies context, right? There's all sorts of precedent from the Supreme Court and from the Federal Circuit when the president. This is a case where the statute delegates express and extraordinary authority to the president in the area of foreign affairs and national security. It's different than a delegation to the Department of Commerce to take certain action under the education statutes with respect to student loans. In that context, the Chevron former Chevron framework would apply. But in the context where the president is actually acting pursuant to national security, courts give great deference to the president. It's just an entirely different framework. It's like the Trump versus Hawaii framework.
Does it matter that the national security instruments being applied here fall squarely within the prerogatives of Congress in Article 1, Section 8?
So does immigration, Your Honor, that falls within Congress's authority to control immigration. Yet, even in the immigration context, Congress has delegated to the president Section 212F, which grants him extraordinary authority to restrict entry into the United States. And the Supreme Court said in Trump versus Hawaii that that was a permissible use of that authority, notwithstanding other reticulated immigration statutes.
Last week, your colleague indicated that the Hawaii case was like this case because Article 1, Section 8 gave the Congress authority over immigration, and nonetheless, what ensued we had the Hawaii case where the president was allowed to proceed. Well, I read Article 1, Section 8, and it doesn't say anything about immigration. It talks about nationalization, the rules of how you become naturalization, how you become a citizen. There's nothing in here about immigration. And we have clear statements about tariffs and duties in Article 1, Section 8. I like taking out my little book. Everybody remember Senator Byrd? I'm too old. You probably don't. He always carried his pocket constitution. So here it is. It doesn't say immigration. It says naturalization, and it does say tariffs. So there's a big difference between this and Hawaii.
I disagree, Your Honor.
Okay, good.
The Supreme Court has said in cases like Arizona, Trump versus Hawaii, Congress is the one that sets the rules of the road with respect to naturalization and immigration. And I think we have a similar situation here where, yes, this is Article 1 authority, but it has been delegated to the president, both reticulated schemes about the immigration laws, about tariff statutes, but we also have emergency authorities that the president can invoke. And I think Yoshida had a great line at page 578 of the opinion that talks about the intersection between the tariff statutes at that time and TWIA, as we were discussing earlier. It said, quote, "The existence of limited authority under certain trade acts does not preclude the execution of other broader authority under a National Emergency Powers Act," end quote. And of course, they said that in the context of interpreting that statute to authorize tariffs. So too here. The fact that we have other reticulated tariff schemes, 301, 232, 122, doesn't mean the president doesn't get to act pursuant to an emergency authority. Congress has enacted multiple overlapping and complementary statutes. And it makes perfect sense why Congress would want to allow president to have the discretion in an emergency to exercise his authority to impose tariffs to address national security interests.
Can you point to any other statute in which the Congress has delegated the taxing power without expressly doing that?
The taxing power. I can't think of any off the top of my head, Your Honor. I mean, TWIA is an perfect example, right? Again, Yoshida, there was no express authorization of tariff authority. Algonquin is another one where the Supreme Court was interpreting 232, adjust imports, authorized tariffs.
It was limited to the licensing aspects of that, of the application of 232 there. It is a question that comes up, and you may wish to give further thought for rebuttal on this, because as we know, the founders not only restricted the taxing power to starting in the Congress, but actually starting in the chamber closest to the public, the House of Representatives, which elects its representatives every 2 years. So it is an area of particular importance, I think, in construing what we have before us.
One thing I'll say, Your Honor, there is a case in the Supreme Court this term, FCC versus Consumers Research, involving a non-delegation challenge to universal service statute. Involves these types of questions. But I think here, this is not a tax. This is an express authorization to the president to regulate importation. Same language as Yoshida. The question is whether that language authorizes tariffs. Yoshida already answered that question. It's binding on this court.
I
perceive different statute, right?
No, I don't want to interrupt your question.
Sorry.
No, you go first.
No, that's it.
All right, who's going to go first? I'll go first, but it's a different topic. I perceive a difference between your view of the court's power to review something and what I heard last week. Last week, I heard we couldn't review anything. I couldn't get any statement that any part of Maple Leaf applied. You at least are saying that the first part applies, that whether the president grossly misapprehended his authority under the statute, something like that. And you think, okay, fine. It can't be grossly misapprehended because Yoshida said regulate means tariff. So that's, at least you got to that part.
Let's stop there, Your Honor.
You want to go further than that. The other side says it's beyond his delegated authority. So perceive a difference. You agree that there is some role for the court to play.
Yes, I think we've been consistent, especially in our briefing. We engaged on that threshold question of whether the statute authorizes tariffs. Obviously, Yoshida answered that question. Some question about what is the standard of review. My friend says it's, this is the president acting outside of delegated authority. We say, no, look, the Maple Leaf clear misconstruction standard applies because this is an interpretive question. What do the words mean? This is not a case where, the president or an agency is acting wholly outside of any delegation of authority. There is a clear and unambiguous delegation of authority to the president in IEEPA. The only question is, what do those words mean?
Sorry.
Go ahead.
Okay. If we could go back to what do words mean? The meaning of unusual and extraordinary threat. In your view, is there such a thing as an emergency that isn't declared with respect to an unusual and extraordinary threat? And let me go on. So if not, how do you explain why Congress said that the president can only use IEEPA authority, quote, to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared? To deal with an unusual and extraordinary threat with respect to which a national emergency has been declared. Why wouldn't Congress have just said to deal with a declared national emergency?
So IEEPA is against the backdrop of the National Emergencies Act, right? So the threshold requirement is a finding of an emergency, right? So that finding under the NEA unlocks a suite of powers across the federal government that allows the president and the federal government to act in times of emergency. During the COVID emergency, that declaration of emergency unlocked a lot of healthcare type authorities. In the IEEPA context, Congress said we need an even higher standard. It needs to be not just a finding of emergency, but a particular type of emergency, one that's unusual and extraordinary. And again, I think it shows Congress thought carefully about the standard that it wanted the president to follow. It set up a scheme whereby there's consultation, there's reporting, and there's review by Congress. There's no role in that process for the courts to play. I know it's always a difficult message for an advocate to send to a court, but there is an unusually,
You say it with such a smile.
but I appreciate that. I think we can agree that there's at least something for the court to review, but just not the president's application.
I find it interesting that you want us to say, okay, regulate means tariffs, but none of the other, and Yoshida said that. But none of the other stuff in Yoshida applies. It doesn't have to be rationally related to the tariffs don't have to be rationally related to the problem of, in that case, it was the terrible payments problem. But it was okay because it was less than what Congress had already authorized in column 2 of the tariffs. It didn't go above the non-most favored nation tariffs. We can't rewrite the whole tariff schedules. So all that stuff in Yoshida, what do you want to dicta? Is that the answer?
Well, I think that some of it's dicta, but look, it says what it says about, it did review whether the action there was rationally related. I think it's extremely problematic to apply that type of analysis today, when today we know that the APA standards of review don't apply to the president, which is what they're trying to import. And what they're asking the court to do is second guess the means the president chose to address the emergency. Again, the statute gives him 9 different ways and means he can use to address the emergency. Anything from investigation to completely cutting off everything from coming into the country. That choice is delegated to the president. It's not for a court to second guess whether he chose correctly or whether he adequately explained to a court. I think another point to keep in mind is I think we brought this up earlier is, could the president completely cut off imports or put 200% tariffs on something? Think of the breadth of this statute. It allows the president to completely prevent imports. So under the statute, I think we would have to agree. The president could say no more imports from China, Mexico, Canada, period. Just period. Nothing else can come into the country. If the president undoubtedly has that authority, then he certainly has the lesser authority to condition the importation of goods into the United States on the payment of a monetary penalty, a charge.
Well, I mean, are you saying that the president has the authority to act in the way that you're describing without any relationship to an emergency?
He certainly would have the power to choose that means, and he would need to explain to Congress why that means, how it addresses the crisis. Just imagine, the fentanyl crisis gets even further out of control and the president says, we're just going to stop all imports from Mexico, period. That would certainly stop the problem. That would be an adequate and rational means to address the problem. Here, the president chose a lesser means to address the problem, which is to put tariffs that will hopefully persuade the government of Mexico to address the problem on its end.
Yoshida told us that in TWIA, regulate meant these tariffs were okay. But the problem is, for you, I think, is Yoshida was in its time and place, and a lot of stuff has gone a lot of water has gone under the bridge. We have major questions doctrine. We have CHATA. All these things have kind of changed the landscape. So why should we keep one little piece of Yoshida and nothing else? Why did Congress say now, I think, why did Congress say regulate if they meant tariffs? And do I look at it Yoshida only as it existed back then, the words, or do I say, hey, it's a new day. We got to look at these words in this new day.
So the standards of review may have changed, but the words in the statute have not, right? So the TWIA language, regulate importation, it's exact same in IEEPA. We also have the context of IEEPA being enacted in 1975 after the Yoshida appellate court decision. So we know Congress was legislating on the backdrop of Yoshida, and so that informs the meaning of those words. Now, a lot has happened with respect to Chevron postdated Yoshida. Now we have Loper Bright. Now we have the major questions doctrine. But those doctrines apply to agencies when they fill gaps in statutes. Those are frameworks that courts use to decide whether an agency properly interpreted a statute. Here we have the president acting in an area of foreign affairs and national security where the case law is very strong.
I think I said last week, look, an agency has an organic statute that tells us it can operate in this area, and yet it's limited by the major questions doctrine. And the president, what you're saying is its organic statute is national security. Well, tariffs are related to national security, but they're not national security. It's two different things.
So we do have Federal Circuit precedent, I think Florsheim and...
Yeah, because it's related.
But in the tariff context, recognizing that the president gets great authority in this area. And I think what's really important about doctrines like the major questions doctrine, that flips the presumption and requires the government to show a clear delegation of authority, right? In this context, we have a clear delegation of authority. In IEEPA, we have the president. He's not filling gaps. He's applying and enforcing a statute that Congress has expressly delegated to him. The only question to decide is whether that phrase, which Yoshida interpreted, means the same today as it did then. And
you're having a lot of argument about something that's clear.
You think you can enter judgment for us today? Yes, it's clear.
I think it's not clear to everybody or we wouldn't be here. So,
but we talk about duration for a moment. The IEEPA, I didn't mean.
No, please.
Please.
IEEPA, the legislative history indicates that emergencies are by their nature rare and brief and are not to be equated with normal ongoing problems. So in his televised address announcing his tariffs in 1971, President Nixon said this import tax is a temporary action. He used that word that I haven't seen used, temporary. Now, we've looked at what's in the executive orders and some other sources. The president said until it stops or is seriously limited. He said because they know they are here, big business is not worried about the tariffs because they know they are here to stay. He has said, referencing the Secretary of Agriculture, that this relates to a water issue with Mexico until Mexico honors the treaty and gives Texas the water they are owed. None of this says temporary or rare or brief. Can you help us understand how that fits into the structure of
Yes,
IEEPA?
there is a temporal limitation in IEEPA, and the president acted pursuant to IEEPA, and the temporal limitation is that an emergency declaration lasts for a year. Of course, it can be renewed, and we all know emergency declarations tend to go on for a long time. But look at the COVID emergency declaration. That went on for a few years, and then there was political pressure on the government to end that emergency, and eventually it was ended. So I think it's telling you have a number of executive orders from the president. You can tell that his strategy is working because with respect to Canada and Mexico, he adjusted the tariffs after some initial negotiations with those countries. So we could be in a situation by the end of the year where the tariffs are no longer necessary because those countries have taken the action that the president deems appropriate to address the national security crisis. We just don't know. But I think the president didn't need to repeat the temporal limitation because that's inherent in the statute. And we won't know until this time next year whether the president.
But wouldn't the legislative history, sorry to interrupt, but wouldn't the legislative history be referring to something other than the fact that IEEPA has this structure for the renewal of the emergency every year?
Well, I don't think so. I think Congress intended Congress defined the standard, right? Unusual and extraordinary emergency, but then it baked in a separate provision that has the temporal limitation. And so that's what I think Congress was referring to in the legislative history, that yes, we recognize we're giving the president an extraordinary authority, but it's only intended to be limited in time for a year. The president's supposed to consult with us, supposed to issue reports. We get an opportunity to review. I think that goes into, Judge Katzmann, your concern about what are the limitations that we talked about earlier. They're temporal, they're procedural, they're substantive, addresses any non-delegation concern you might have.
Well, going to the question of limitations, and also to a point that Yoshida makes, expresses a concern about an executive who is acting pretextually. And even if the president claims perpetual IEEPA powers, I think the pretextual emergency is the only way to address that would be for Congress to assemble a veto-proof majority in both houses.
Yes, or political pressure, right? Congress set up this scheme and it has checks. The check is, this is a collaborative process between Congress and the executive. If Congress disagrees with the president's declaration of emergency or abuse of that power, there are not just this check in IEEPA, but there are other political tools that Congress can use to put pressure on the executive to no longer continue to use that emergency authority.
There really isn't any special check by the Congress after Chadha, right? There's no special check.
Well, with respect to the vote threshold, yes. But there is part of the statute is Congress is supposed to have a vote and supposed to vote within a certain number of days, right? Like that is a special review scheme. It's different than the Congressional Review Act. It's more specific to it is specific to this particular statute. The Congressional Review Act is a generalized check on executive rulemaking. This is something that Congress built in specifically into IEEPA and the National Emergencies Act is the ability of Congress to review and take a vote.
I'm just wondering why we have all these statutes if president can do this. I mean, got a lot of statutes out there, 122, 232, 301, 201, not to mention all the anti-dumping countervailing duties. Why are we bothering with all this, with all that?
Congress, in its wisdom, has seen fit to give the president a number of specific authorities that address particular problems and have their own procedural and substantive limits, 301, 201, et cetera. But yet Congress has also recognized there may be emergencies, and the president needs to act with flexibility and dispatch in an emergency.
Can I ask you a question, which I also asked your brother? And that was the question relating to the U.S. Customs and Border Protection reported that in 2024, almost 97% of all seized fentanyl was intercepted at the southwest border, while less than 1% was seized at the northern border. And yet, the president's executive orders have imposed tariffs equally against both countries. Does that disparity affect your analysis?
No, it shouldn't affect your analysis either, because
I thought you would say that, but does that affect your analysis?
There really is no standard to judge, like under the IEEPA. If you accept our argument that there is tariff authority, right? There's no standard by which you can judge whether a 25% tariff or a 10% tariff is appropriate. But what the president explained is that Mexican cartels have come to the northern border in Canada, and that is a threat to the expanding the fentanyl operation in Canada. And the amount of fentanyl that comes across the northern border every year could kill 9.5 million Americans. The president didn't want that problem to spiral out of the control and come to the same level of a crisis that we have had at the southern border. Again, I think this is a fundamental problem with their case, is they're asking the court to second guess and quibble with the means that the president has chosen, and they're trying to subject the president to APA review.
I think your answer is the same as your colleagues, and I'm not going to use any foodstuffs. Nothing is so crazy or unrelated that it could be stopped by the courts. Anything is allowed. Anything crazy, any declaration of emergency based on some crazy thing, any remedy, how crazy as it could be, it's all okay because the courts can't do anything.
I would not go that far, Your Honor. You know, I've conceded you can review the interpretive question. If the president...
Okay, but that's all you've got. Is all you say the courts can do is look at the statute. But the courts cannot decide that this particular action based on this particular declaration is way outside what Congress intended.
No, if the president clearly misconstrued IEEPA and let's say chose a tenth measure that is not articulated in the statute, that doesn't fit within the words investigate, prevent, regulate, it's hard for me to imagine what that would be, because Congress used very broad language.
Yes, you always get back to the words of the statute, but nothing the president does. And you basically say nothing can be reviewed. It could be really outside the realm of reason and it can't be reviewed.
Well, at the end of the day, Congress can review. Congress can put pressure on the president.
By a 2/3 majority in each house of Congress, it can decide that this is too crazy.
Congress could repeal IEEPA. Congress could take any number of measures, could not confirm the president's nominees. At the end of the day, that's the system that our framers set up.
I don't actually intend to say this is crazy, but I'm trying to give you an example without using a foodstuff. You get the point?
I do. Again, you can review the interpretive question. If you don't think the president's authorized to use the statute in this particular way, that's a way for the court to check the executive. There is controlling precedent in this circuit. Yoshida. See, my time is up. Thank you.
Thank you, counsel. Want to take a break or want to?
How much time do they have left?
I think it's closer to 15 minutes.
It's okay with me.
Yeah, okay.
Speed ahead.
Yeah.
Did we need to ask the counsel?
Sorry.
Okay. Are counsel okay with going ahead?
I would prefer a break, but if the court prefers that we go ahead, we go ahead.
No, why don't we take a break?
Okay, thank you, Your Honor.
10 minutes, 10 minutes.
All right.
Forgot to
Okay.
The option. Never bothered to change. Do it illegal when it's much for this, right? Yeah, we do.
All right. This honorable court now resumes its session.
Please be seated.
Okay.
Mr. Marshall?
Thank you, Your Honor, for your patience among the court's many other courtesies provided to this case. I wanted to start by addressing the question that I deferred from Judge Rastani about Section 122. In case there was some lack of clarity, we are not asserting that it is a balance of payments problem. What we're saying is that it is a balance of trade solution, is what the president is trying to impose, and that Congress has said the balance of trade solution with tariffs is available under the circumstances and with the limitations of Section 122. All of those individual sub-authorities under A are all things trying to achieve the balance of trade. Now, I did misremember the balance of trade phrasing, but I don't know how persuasive you'll find this, but I believe it's subsection C, there is, when it starts talking about trade surpluses, it talks about balance of trade. So it was clearly on the mind of the drafters of 122. And so the thinking there is not that they are limited because they are claiming a balance of payments problem, but because this is the mechanism by which a balance of trade solution can be imposed.
Yeah, I thought it was an odd drafting that the balance of trade was in the surplus situation. It just seemed like I couldn't see how it could be that important to have it in the surplus, use those words in the surplus situation, but not mean it earlier.
Exactly. And so I think that it's what is subtext in sub A is explicit in sub C, but both read together, I think, are there. Going to the broader themes of this case, I think this is a rare case where the plaintiff's characterization of the government's position is just the government's position. We said at the beginning that this is a blank check, and what we heard from the podium from the government is that the only limit is what powers exist under the statute. There's no limit based on whether the emergency is declared or whether it bears any relationship to that emergency. So whether it's peanut butter, whether it's Canadian dominance in hockey, whatever the reason, the courts have no place under the government's interpretation, and tariffs are a solution. The problem with that, among others, is that it swallows all of Title 19 whole. So long as the president wants to impose a tariff, he can do it for any reason he says, so long as he says it's an unusual and extraordinary threat. I think that is inconsistent with IEEPA for basically two categories of reasons. The first are that there are pieces of Yoshida itself that this is what Judge Rastani's questions were getting at. There are pieces of Yoshida itself that Congress, when it enacted IEEPA 2 years later, was relying on the court that it would, in fact, enforce a reasonable relationship requirement and the limitations that Yoshida said, which was it found significance of it being within the statutory column 2 rates. Now, I want to answer a question that wasn't asked of me, but was asked of my colleague on the other side. Is this dicta? It's not dicta. It was part of the holding that the Yoshida court had to reach in order to come to a conclusion on the plaintiff's non-delegation claim. All of those limitations there were actually part of the holding that there was not a non-delegation problem because there were material limits within the TWIA authority.
How does the concept of material limit differ from intelligible principle?
I think I'm really referring to the enforceability, right? So I think that they are right that there could be an intelligible principle, but there was a jurisdiction stripping statute. But IEEPA is not a jurisdiction stripping statute. It contemplates judicial review. And at 50 USC 1702C, there's a specific, my colleague talked about classified information. It tells the court how to deal with classified information. It knows that the court is going to be here, and it says that in any judicial review of a determination under this section, if the determination was based on classified information, Congress was not thinking that it had created this court for no reason at all. It was thinking that there would be judicial review, that there would be meaningful judicial review, and the judicial review would not be, is this a tariff? If so, go home, everyone. That's what they're asking for. It is a meaningful relationship. And so Yoshida is one piece of it. And the other piece of it is also that Congress, when it enacted IEEPA 2 years later, was raising the bar in important ways. And the most important way is that it said that only unusual and extraordinary threats count. And that was a direct reaction to the Yoshida court's determination that it could not determine whether or not there was an emergency. And so once Congress was told that, it reacted by saying, okay, if you can't determine whether it's an emergency, then we're going to say that the president has to provide that it is an unusual and extraordinary emergency. And those are an emergency that presents an unusual and extraordinary threat. And those are the types of terms that the judiciary can and does interpret. And so their basic argument seems to be that this entire thing is a political question. But the point of IEEPA is to react to Yoshida's finding that that the emergency declaration was unreviewable. That it was essentially a political question. And so it created a new statutory standard layered on top of that emergency declaration that the president would have to fulfill, not in just say the words, but in fact, survive judicial review by a court that is in fact meaningful.
Now, didn't they actually mean survive our review? Because at that time they thought they had the two-house veto.
I think they meant both. And I think part of the way you can see that is with 50 USC 1702C, which is assuming that there's going to be a review, that you may be called upon to think about classified information. I mean, if Congress thought there was going to be no meaningful judicial review and that you were supposed to take the factual representations of the government at their word, we're not even making factual disputes. We're saying just make a legal determination based on everyone's agreed upon set of facts. And I think there's an even more rigorous review that was assumed by the drafters of IEEPA. The last point I want to pick up on is the new day point that Judge Rastani said about revisiting the question of whether tariffs are allowed to be imposed at all. And I think the jurisprudential change of the major questions doctrine is in fact a significant change. Justice Barrett's concurrence in Biden against Nebraska says she traces back that doctrine to a series of decisions starting in 1980, 5 years after Yoshida was decided. And so it was a doctrine that the Yoshida court just didn't have the benefit of when it made that decision. And intervening Supreme Court decisions displace earlier circuit precedents. That's what Troy v. Sampson Manufacturing says, a federal circuit case that we don't cite in our papers, but I think is important, that, and it's quotes the Ninth Circuit saying lower courts are bound not only by the holdings of higher courts' decisions, but also their mode of analysis. And this is the kind of mode of analysis that there's an intervening judgment.
Can I ask you about remedies?
Yeah.
I think I know what you're going to say, but I'd like to give you the opportunity to answer. What would your ideal slate of remedies look like in this case?
First, the easy one, declaratory judgment, saying that these tariffs are ultra vires. The second is vacature of the CBP bulletins that we identify. And then the third is a permanent injunction, or if the court somehow doesn't, I think there's no reason that there is, I'll just say it's a permanent injunction because I think there's no question that everybody agrees that we're ready for summary judgment, that a permanent injunction is necessary to remedy the state's injuries here, because the state's injuries here include situations where we are not the direct purchasers, or we are not the importers of record. And so we purchase from some other importer. And so if that importer 3 years from now gets a refund, the states aren't going to see any of that. And so the only way to really remedy the injury that we are facing is to provide us with an injunction.
Now, this also ties into the question of standing. And as you know, there's a question as to whether the non-importer states, there might be a question as to whether the non-importer states should be dismissed. What impact would that have on this case from a perspective of standing?
Well, it would, there's still a justiciable controversy, and you can still provide the declaratory judgment. If only importers of record are the only ones allowed to get a remedy, then I think it's hard to see. I agree with my colleagues on the other side that it's hard to see how we have irreparable injury in general. There are still irreparable injuries that we identify, the budgeting injuries, the fact that they aren't using the proper statutes means that we don't have a procedural vehicle to levy our objections. Those I think are significant, but I think that it does undermine our injunctive relief point. But I respectfully disagree that what I would call indirect purchasers or purchasers, I think is what the government calls them, do not have standing. There's a clear economic logic to this. We have declarations that support it both in general through the Hines Declaration, and then in specific through the declarations of our states. I think the Minnesota Chief Procurement Officer's declaration, that's 14-5. Exhibits C through E are particularly persuasive about this because they show how direct it can be. That there is a specific contractual provision that says that the importer, the person they are purchasing from, can just invoice the state of Minnesota for those charges, and so it's quite clear that there's a direct injury. And I think in footnote 1 of our reply brief, we point out that the courts confront this question all the time in the situation of looking at the antitrust laws and how indirect purchasers are treated under there, there's never been a suggestion that indirect purchasers in the antitrust laws don't have Article 3 standing. As long as we can show injury, traceability, and redressability, then that's all we need for Article 3 standing.
I know you didn't want to bring a constitutional challenge. Nobody like Schechter Poultry. Been a while. It's a while since that was around. But I guess there is an underlying constitutional aspect to your argument in that if it's a wholesale delegation from Congress to the president of tariff making authority, then that would violate Article 1, Section 8.
Yes, and we disagree that that is what is occurring, that we think that Congress created standards and that the doctrine of constitutional avoidance as a matter of statutory interpretation is a reason to disfavor the government's interpretation that this is a blank check and that so long as tariffs are authorized at all, they can do what they wish. And so one of the reasons that that statutory interpretation is implausible is that it would run into that limit. And so there is the doctrine of constitutional avoidance is ready-made for this. It's not as if the Congress said, President, do what you wish with tariffs, but that's the government's interpretation of the language that they created. And one of the reasons that doesn't work is the doctrine of constitutional avoidance counsels against it.
Can I ask you about the Federal Circuit decision in both Chorus Group and USP Holdings, where the Federal Circuit concluded that Section 1581 does not authorize proceedings directly against the president. And I was wondering if you could address that. Of course, the president is named in his official capacity. It's obviously not a personal suit.
Yes, and I think that we can get all of the relief we need against the United States and the other defendants. I think if he is dismissed, that there are
the other defendants. They're all acting in their official capacities. Couldn't this just be a suit against the United States? End of story.
It could be. It could be. I mean, I think we're being protective of our rights in a number of ways because we anticipate there will be further review of this court's decision. And so questions of intermediate courts of appeals could be potentially on the table. And so we wanted to be protective of our rights by both naming the agencies. I mean, I think the agencies are necessary because those are the only ones under which we can proceed against the APA. But in terms of the relief on the ultra vires claim, the United States is wholly sufficient, and this court's jurisdictional statute is a waiver of sovereign immunity.
Right.
Thank you.
Thank you. Counsel, Mr. Shoemate.
Thank you, Your Honor. I think the real quibble my friend has with this case is really about reviewability. There are limits in the statute. Really, question is who enforces those limits? And I think I've been clear today that the court can review the interpretive question of whether the statute authorizes tariffs. But as to the question of whether the president properly invoked the statute, whether he reasonably explained himself, whether the means justify or have been justified, that all smacks of APA review that doesn't apply to the president. And ultimately, at the end of the day, this is a question for Congress. Congress gets to review and consult with the executive about whether emergencies should continue. And Judge Rustani, we talked about the statutes. I wanted to point you to one statute it's part of the National Emergencies Act. It's 50 USC 1622C. 5 reticulated paragraphs about how the joint resolution is supposed to be introduced into both houses of Congress, how many days it takes to vote. Yes, the vote threshold to overcome a veto is going to be 2/3. But that is the scheme that Congress set up about how these emergency declarations are supposed to be reviewed. So at the end of the day, it's really equivalent with the scheme that's Congress set up and the political question.
Again, I have a question. So you say that this is the scheme regarding congressional involvement when this system was set up, but that was, correct me if I'm wrong, that this was set up prior to charter.
It was set up prior to CHATA, but this statute remains in force today, and that's the process that works. It worked with respect to the COVID declaration of emergency. Congress disapproved, and that emergency declaration and all of those authorities went away. It is an adequate and effective means to check the president. And just to go back to the procedural issues we were talking about earlier, again, the plaintiffs have not raised a procedural claim, nor could they, right? That would be an APA type claim. But in any event, the president and his administration did comply with all these procedural requirements. There was consultation with Congress before the tariffs were announced. USTR went and briefed.
I'm not sure if a statute has procedures the president must do before he does something. That's a kind of procedural claim that's not an APA claim.
Yes, they have not raised that claim, but they also need a cause of action to bring that type of claim, right? They haven't brought that claim. That's a type of claim that would be typically cognizable under the APA, right? You didn't do the notice and comment properly.
I don't know. If there were procedures before the president could do this, and he didn't do them, then somebody could bring a statute and say, hey, I'm injured by this, and he didn't do the procedures. That's what Maple Leaf says we can review. Not what the agencies do as a procedure, but what the president does as a procedure.
But here the procedures are congressional notification. And typically congressional notification statutes and reporting requirements are not something that a private plaintiff, or even a sovereign plaintiff could complain about, right? They're not within the zone of interest of any type of reporting requirement to Congress. They're not injured by that. They can't complain about it. The only party that can complain about it would be Congress.
Let me ask you something else. I want to ask you about this classified information, section C. In any judicial review of a determination made under this section, blah, blah, blah. If it was, what is the judicial review of a determination made under this section?
This is 1702.
This is the classified information. So I'm just wondering what the judicial review of a determination made under this section is. That's a 1702.
Right.
Paren C. The classified information thingamajig.
Right, I see it. Look, Your Honor, we have not briefed that issue. This is not a case where classified information has been presented to the court.
But the statute says in any judicial review of a determination under this section, and I'm just wondering what the determination is.
Well, the determination here is the president's decision that the statute authorizes tariffs, right? If for some reason you needed classified information to make that interpretive decision.
Right, I know what this says. Yeah. It just seemed like, I don't know what they meant by this, but the determination they're talking about is something other than this is classified information or not classified information, because it says in any judicial review of a determination made under this section, if the determination was based on classified information. And I think by the section, they mean they mean more than the classified information determination. They mean judicial review of something.
And we're not disputing that there would be judicial review of this interpretive question, but at the end of the day.
Why would the court be looking at classified information to decide what the words of the statute mean? Because you say that's the only thing we can look at.
Right. I don't know, Your Honor, but what I do know is APA review is not available. So you can't review any determination like that under the APA. It doesn't change the standards for the political question doctrine or all of the precedent that forecloses judicial review of emergency declarations.
Is an executive order a law of the United States for jurisdictional purposes?
It's a law of the United States. I don't think so. It's not. It is binding on the executive branch, but it is not something. It's not a statute or regulation that has the force of law.
And so, in your view, it may not be jurisdictional for the purposes of 1581I.
Well, I think you're getting into the Florida case that's going to be coming to you. I'm not going to do anything to undermine that decision.
I don't think the Florida court talked about that. I think they only talked about IEEPA as providing for tariffs, and that, quote, since it provided for tariffs, or Yoshida said it did, that it's a tariff. It's a provision of law that providing for tariffs, and therefore it's here. I don't think they ever got to, I don't know that, did anybody tell them that the court, that there is 2 volumes of HTSUS, a statute of the United States that provides for tariffs, and these executive orders made amendments to the HTSUS. Did anybody argue that to the court? Or did this poor district judge who has plenty of things to do had to get involved in this when maybe he didn't need to?
I think we can agree that court got it right. And that case will be coming in.
What they got right was this court has jurisdiction.
Right.
But did the government tell the court there that the HTSUS was a statute of the United States and it had been amended by the executive orders, and that these tariff provisions were in HTSUS, a statute of the United States? Did the government bother to tell the court there that?
I don't recall if we made that particular argument, Your Honor.
Turning for a moment to the question of standing.
Yes.
Just to get your position on this, just to make sure that we're clear on your position. If hypothetically we dismiss the non-importer states, what practical impact would that have on this case?
If you dismiss the non-importers, then my understanding from the record is the only importer of record would be Oregon or their instrumentalities. So that would be the only plaintiff with standing. They would have standing to raise their claims, but the only remedy that would be available would be a party-specific remedy as to the plaintiff as an importer. So any type of nationwide relief or relief that goes beyond that importer would be off the table. If I can address the question of injunctive relief, we do not think that would be appropriate for a number of reasons. Number one, monetary relief would be available at the end of the case. We've said in our brief, refunds would be an available monetary remedy. And where you have the availability of a remedy like that, there's no irreparable harm.
So you would want us to stay the liquidation of all the entries for all the parties?
I don't think you need to enter any type of injunctive relief or stay. The government has represented.
Okay, they're not going to get the money back if they're importers. They're not going to get the money back unless the entries remain unliquidated. So I think that's how it works. But let me ask you this: if we have 12 states with standing, and they say they are generally injured by these tariffs in particular ways, that is, their contracting problems, et cetera, and we find that they have standing, then we would say, okay, none of these tariffs apply to you, state, and 12 states would have no tariffs, and the rest of the union would have tariffs?
No, Your Honor.
I don't think that's the way it's supposed to work.
No, that's not the way it's supposed to work, and that's not how the remedy would run. Even if you said 12 plaintiffs have standing, 12 states, the relief would not run to the citizens of those states. They're only claiming an injury as a state, not as a parents patria on behalf of all of their citizens. So Oregon is claiming an injury. The other states are claiming injuries as importers. And so that party would be entitled to relief, but not all the citizens of those states.
Well, I think they're not claiming relief just as importers. They're claiming relief because they can't, I do believe they said they couldn't contract properly because of what was happening, that certain uncertainties have been created, what caused economic problems. I'm not sure how you fashion relief short of a broad injunction if you have something that goes beyond their particular imports.
So again, we don't think they would have standing to complain about these.
But if they did, if they had standing to complain about the fact of the economic losses they are facing because of the general tariff issue,
right?
Then, and we have to frame and they win, and we have to frame a remedy, then limiting it to their imports doesn't give them the relief they seek.
Look, I think if you're trying to remedy an injury that goes beyond as an importer, then right, your hypothetical is
my hypothetical is their injury is more than as an import. That's the hypothetical. So what do we do if their injury is more than as an importer?
So again, they still have to show irreparable harm, right? So refunds would be available to some parties, whether that gets passed.
Oh, it would be, right. If some importer somewhere challenged the imports, then they could get relief in that suit. I don't understand how the states would get relief from some other importer's suit.
Okay, so assuming they've established all their threshold requirements to get relief, at an injunction stage, you have to weigh harm to the other party as well as the public interest. And here, an injunction would be extremely disruptive. While the president is in the middle of foreign negotiations with other countries about trade deficits and about the fentanyl crisis, an injunction would completely kneecap the president at a delicate time when he's on the world stage trying to negotiate trade deals.
Well, if the president isn't doing something he's allowed to do by a statute, then there's nothing the court can't decide that, okay, it would be better politically for the world, for whatever, for the president to do this, but he's not allowed to do it by statute. So therefore we allow it. I don't think we can do it that way.
Well, when you have other remedies, yes, you can.
Okay, what do you do?
And when you're talking about an equitable remedy, that's an equitable remedy. You have discretion and there's a 4-factor test and that weighs the public interest. So even assuming these tariffs are unlawful, which they're not, there are other remedies you can award. It needs to be limited to the plaintiffs in the case. And at the end of the day, you need to weigh the disruptive impact of any injunction. And my last point would be, look, if you're going to enter that type of disruptive remedy, an injunction, it should be stayed pending appeal to allow the Solicitor General to seek emergency relief from the Supreme Court.
Okay. There is always that option, either here or in the Court of Appeals, should you not get your way.
But again, Your Honor, at the end of the day, we think there's controlling precedent from Yoshida that answers the question presented. The political question doctrine answers the questions about whether any of this application of the statute is reviewable. So we would ask the court to enter judgment for the federal defendants.
And can I also ask for your position on Chorus and USP Holdings? If the caption of the case were changed to state of Oregon versus United States, would that not cure any of the potential issues in naming the president in his official capacity?
I don't think so, Your Honor, because at the end of the day, we've got an action taken directly by the president, and any type of relief here would be an injunctive order against the president. Even if you were to remand to the president to ask him to explain further, that is something that would be operating directly against the president. Now, in other cases, sometimes it's appropriate to enjoin or restrain the lower officials who might take action pursuant to the president's direction. But here, the president himself has taken the action. That action is not reviewable, and it wouldn't be appropriate to bypass restrictions on reviewability by substituting other defendants.
Well, he's taking it in his official capacity as president of the United States. So, and any relief would be against the United States.
Well, but Mississippi versus Johnson and many other cases say, even in cases where the president is being sued in his official capacity, courts don't enter injunctions directly against the president because that tees up a separation of powers problem.
They wouldn't enter it against the president. They would enter it against the United States.
I don't think the United States is a party here. We have other agency defendants. Relief could be entered against them, but the only relief I think I've heard them ask for that would run against the agency defendants would be vacatur. But there's really no EPA claim against the agency defendants. They haven't taken any final agency action. They have merely taken ministerial action to implement the president's direction.
To the president's direction.
And his action is not reviewable under the APA, and therefore the vacatur remedy is not available either.
You have not moved to dismiss the president in his official capacity.
We have not. We typically don't do that in our cases because the case law is so clear that any type of injunctive relief couldn't run to the president. Typically in our briefs, we say, if you're going to enter any type of injunctive relief, don't have it run against the president. So we would repeat that request here, either dismiss him as a party, but if you are going to enter any type of injunctive relief, don't have it run against the president, and please stay at pending appeal.
Thank you. Any questions?
Thank you very much.
Counsel. That concludes our arguments. Once again, we'd like to thank counsel for the enlightening arguments and the briefing. And also to say that our questions should not be construed as an indication of any direction in our decision. Also, this is not a case about, trade policy or what is the best trade policy. It's about statutes, the branches of government, and what is permissible and what is not violative. And these arguments were extremely enlightening. And we would also like to thank our court staff, everybody at the court for all your help. And we hope you have everybody here. Safe travels. And we look forward to seeing you again. Thank you.
All right. Court stands adjourned.
You're in your own post.